Welcome to You Counsel. Many people who do not have a lot of experience in our judicial system, in our court system, have some fundamental misconceptions, misunderstandings about how judges decide on different cases. And in those misunderstandings, what happens is that they end up losing their case, even though they may have good merits, they may have good case, but because of their basic misunderstanding of how judges decide, they at times end up losing their case. So in this lecture, I want to explain some of these fundamental misconceptions and then explain how the judges make decisions in our court system. But before we do that, I want you to know that this lecture is not legal advice. So if you have any specific questions, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. So we'll talk about those fundamental misconceptions, and then I will explain to you how the actual decision making is done in our courts. Now, with respect to fundamental misconceptions, I'm going to give you some of the items that I believe are fundamental, and I've defined it, labeled them in certain ways. First one is called character reference. Now, character reference is where a litigant basically says to the court, I'm a good person, I'm an honest person, I've never lied, I'm a religious person, I believe in God, whatever, anything that talks to their character, and on the basis of that character, they want the judge to rule in their favor. So the argument essentially is, I am a good person, I never lie, I'm an honest person, therefore you should rule in my favor. So it is very important to understand that character references are 99% of the time irrelevant. The courts do not take that into consideration unless character is one of the issues in that specific case. But for example, if you are in a breach of contract case, whether you are a good person or not, or whether you are an honest person or not, or people like you, is irrelevant. The question for the court is whether you breached that specific contract in which you are here, right? And so your character reference, and I've seen a lot of people, even my clients, try to argue this, that because I'm a good person, the judge should believe me. That is not how it works, and that is one of the fundamental misconceptions people have about how judges decide. Number two, reference to personal circumstances. So for example, if the case against you is that you had a credit card and you took money, you paid for certain items and you are not paying and the credit card company has sued you, making reference to your personal circumstances is not going to help you. So for example, if you come to the court and say, I am poor, I don't have enough money, or I've lost my job, or I'm a single father or a single mother, or I have little kids, and therefore you should get me off the hook for this payment on this unpaid credit card, that is not going to help you. Personal circumstances are irrelevant in the decision-making process, unless, of course, personal circumstances is one of the key issues in the case, but, very rare. Especially like an example that I gave you about unpaid loan kind of stuff, personal circumstances are not what is going to make a judge's mind about ruling in your favor or against you. Number three is somehow people believe that somehow judges who are honest people, somehow they're going to divine the injustice behind their situation. So regardless of the fact that they may not have strong evidence, regardless of the fact that they may not have presented their case in the best light, with the best of the evidence, somehow the judge is going to see through all of the facts and figure out what is happening behind the scene. That is not the judge's role, and that is not what judges do. Judges are not seers, they are not clairvoyants, and it is not their job to figure out what is happening behind the scene in the absence of evidence. They have to figure out the truth of the matter based on the evidence, but they're not going to discover some reality that exists outside of the evidence that is presented to the judges. And relating to this point is that somehow people believe that because I'm a good person, because of my personal circumstances, because judges can see through, somehow the judge will become my advocate. The judge is going to come down from the pulpit and help me in succeeding my case because of all these things, and regardless of the fact that my case, that the way it has been presented, the evidence that has been presented, is not helpful to me. So that is not what the judges do. And the most that I have seen in my experience is the judge will make a comment to a party saying that, so-and-so, Mr. So-and-so, Miss So-and-so, I suggest that you should seek some professional help with respect to this case. Now, that could mean one of the two things. One is that your case is terrible. If you continue, fighting with this case and proceeding to trial, then I won't have any other chance but to sort of rule against your favor. So why don't you go talk to a professional and understand how the system works and understand your exposure so that you can prevent that from happening. Or the judge may believe that, look, this seems like a better case. There may be some merits to it. It sounds like it. But the way you're presenting it, it's not going to help you, right? So go find some professional help. Try to understand how we decide our cases so that you can present your case properly. And that does not mean go hire a lawyer, but at least get an understanding, professional understanding of the system, of how to present your evidence and how to present your case so that you allow the judge to rule in your favor. And finally, the fifth circumstance is what I call the David versus Goliath circumstance. The underlying argument here is that because I am David, therefore you should rule in my favor. I am David. I'm the little guy. I'm fighting against Goliath, this big bad corporation, big bad institution, big bad person, whatever. And because I am David, somehow you need to help me out here. That is not what judges do. Judges do not treat Davids and Goliaths differently. In the eyes of the judge, David and Goliath have the same value, same respect, same significance. If David has better evidence, David is going to succeed. If Goliath has better evidence, Goliath is going to succeed. So it is not a situation where the judges are going to come down from their pulpit and help out David because of the low size, the smaller resources of David as opposed to Goliath. Okay, so we talked about the fundamental misconceptions. Let's talk about how the actual decision making works. First point that I want to explain is that it is important to understand our judicial system is based on adversarial process. The opposite of that is the inquisitorial process. In adversarial process, the fundamental concept is that both sides have their own lawyers or own legal professionals or own case, and they are going to present their case to the judge pursuing their own interest. And when all parties are pursuing their own interest, presenting their best evidence to get to what they want from the court, the truth is going to emerge from that, the fight between the adversaries, right? So the truth is going to emerge from that exercise when each party is trying to present the best case to the best possible manner to the judge. And once the truth emerges, obviously the judge sort of figures that out, and then the judge rules on that in the favor of the party that has more merits. Now, inquisitorial process is different. Inquisitorial process is there's no sort of adversaries in that case. It's essentially one person, one body that is tasked to find the truth. It is their goal is the search of the truth. So, for example, in our Canadian system, we have these commissions of inquiries that are created by the government oftentimes. Gomery Inquiry or Truth and Reconciliation Commission or Walkerton Inquiry, right? So these are inquiries. These are inquisitorial process, usually run by a retired judge or someone of that caliber. And their goal is that they go and follow all the evidence. They go where the evidence leads them. And then their end game is to find what happened. Their end game is the truth. They're not resolving a dispute. What government does with the final fact finding is up to the government. But the goal of that commission, goal of that inquiry is to find the truth. Adversarial process is not the same. In adversarial process, as I said, two parties are fighting, or three parties or multiple parties are fighting and presenting your case, and we're hoping that truth will emerge. Now, in many, many cases, truth will emerge in adversarial process, but in some cases it won't. So there are advantages and disadvantages of adversarial and inquisitorial process, but I'm not going to discuss that today. Point here is that in adversarial process, one of the challenges of the process is that one party may have a lot of resources, financial, may have competent lawyers, high caliber lawyers, a team of lawyers, and the other side does not have enough resources, enough competence, enough capability to present its case in the best light. And now, so the challenge in that situation is that it is possible, not always, but it is possible that the weaker side may not be able to present its case in the best light, and therefore their truth does not emerge the way it ought to have been done if both parties had equal fighting capability. So that's sort of one of the weaknesses of the adversarial process, but that is the process. It is important to understand that you like it or not, that is the process, and that is how courts function. In the adversarial system, evidence is the king. I cannot emphasize this enough. Judges make decisions on the basis of evidence that is presented to them. If your uncle who lives in Bahamas, and you're telling the court that my uncle who lives in Bahamas and who is sick and cannot come to the court, but he knows the truth, he saw the specific instance that you're presenting to the court, and therefore you should be believed, the court is not going to rule in your favor because the evidence of that uncle who is sitting in Bahamas is not before the court. So the court is not going to divine some evidence that may have existed. That is not the role of the court. The court is going to make its decision on the basis of evidence. May the best evidence win. So if you are not presenting evidence to the court, and you just believe in your heart that unfairness was done to you, that is not sufficient for the court to rule in your favor. And finally, on this point, I want to explain that justice is not the prime goal of the judicial system. And this, I don't mean to be crass, and I don't mean to minimize the value of our judicial system, but it is a point that it is important for general public to understand. Now, this is not a new thing that I'm posting it. Legal scholars know about it, academics know about it, judges know about it, lawyers know about it. Everybody who's in the judicial system knows that justice is one of the goals, an important goal, but it's not the prime goal, because the role of the court is a resolution of disputes that is before it on the basis of evidence that is presented. That's what it is. And in that process, sometimes, not a lot of time, but sometimes the result may not be just. But that is the best system that we have. And we need to recognize that the role of the court is to resolve disputes on the basis of the evidence that is presented. So that's sort of the crux of how the decisions are made. And I'm really hopeful that if you are a self-represented litigant or you're a person who has have not had a lot of experience with courts, to really understand that this is how the courts function, this is how the judges make their decisions, so that you can present your case on the basis of the evidence and present it in a way that you are successful on the merits of your case. Thank you for watching.